okay, I told you I would do this and I'm doing it because I keep my promises. That is one thing about me. And I told you I would look into whether we could sue the Secretary of State or the state of Ohio for handing over our voter registration information. So we're going to talk about it. But before we do that, I need you to look me in the eyes and hear me when I say this is not legal advice. Okay? I'm a lawyer, not your lawyer. This is for educational and informational purposes only. I told you I would do some research and see what the law says and possible areas of recourse and things we might be able to do after our information was shared. But I'm not your lawyer. So if you feel like this piques your interest and you think, oh, hey, maybe I want to sue, call your lawyer because this is not legal advice. I'm just sharing what I learned. That's all. I just did some legal research that you could have done if you had time or wanted to, but I said I would do it. So I'm sharing it, okay? Capiche? I'm going to remind you of this throughout the video. So the first thing you have to know in order to sue is you have to have standing. I'm sure you've heard this before. Standing basically means you have an injury in fact, which is an injury that is protected by the law, that the injury was caused by the thing you're complaining about to the court. Like this person did this to me, and that injury was caused by that action of that person. And then the third point is that there has to be something the court can do. There has to be some type of ability for the court to redress or fix your injury, right? That's number one. So do we have standing, all that jazz? Well, we also have to look at is what LaRose did illegal, and it's not automatically illegal. We have to look at what information was given and how it was given and all those things. Well, what we do know is our voter registration was handed over in a pretty little bow to the Department of Justice because they asked, oh, so nicely, right? What did that entail? That entailed our full name, date of birth, address, driver's license number, remember that, and partial social security number. So that information was handed over. Now, a lot of our voter registration information is public record, things like our name, our registration status, and the precinct that we vote in. Those are typically not private, which is why LaRose went out and made a statement of like, oh, well, the information that I gave is already public information. Not all of it. Nay, nay. He's trying to just think that you're dumb. You're not dumb because you're watching this video and you're learning, but it's not legal advice. This is just education. The thing that LaRose did not mention is Ohio has very specific exemptions for what is not considered public in our voter registration. And some of those things are part of a process called the confidential voter registration records, which is tied to the address confidentiality program, which is often used by people who need their address to be private for safety reasons. So that information was not supposed to be shared. Whether it was or not, we don't fully know, right? Also, other sensitive information like, I don't know, social security numbers, those are also treated very, very different from the standard voter information. So we're thinking, well, how did the DOJ get this information? What did they tell LaRose and all these other states? Well, they probably relied on the National Voter Registration Act, which is the NVRA, and it's a statute that basically says that states have to keep records for at least 2 years and make them available for public inspection. So it's a part of this law that says, hey, a voter list maintenance maintenance can be reviewed by public and federal investigators. But that same law has important carve-outs where it says how you registered for, to vote and things like that. Those details are protected, even if other parts of the record are open. It also repeats confidentiality in other parts of its statute, where it says states cannot publicly reveal whether you registered at the BMV, a public assistance office, or another agency. And then it also says that the form promises, this statute, that where you turned that information in also stays private. It talks about transparency a lot in the NVRA, but also maintaining confidentiality a lot in that. The other thing I want to point out is the states that have refused to give the DOJ the voter information of their citizens, DOJ, of course, sued, and the states won. At least 3 federal courts at the time of me recording this said, held to know that the NVRA, as well as Title III of the Civil Rights Act of 1960, and also the Help America Vote Act, these are all laws or statutes that the government tried saying gave them the right to this information. The court said, no, actually, these don't authorize the DOJ to have this full voter registration information on request. It basically is showing that the DOJ lacks a legal basis for just coming over and demanding personal information that's protected under state law. Okay, I told you this was going to be long, guys. I'm sorry. The next issue, and probably the biggest privacy pressure point that I've found, is a different federal law, and it's the Driver's Privacy Protection Act, DPPA. And basically, it's the main federal law that limits when DMV type personal data can be shared. This is huge, so please listen up. This is what we're talking about. I said pay attention for driver's license number. The DPPA creates a system that restricts the state's ability to disclose personal information from motor vehicle records without the driver's consent. Okay, so basically what counts as a motor vehicle record, defined as any record that pertains to a motor vehicle's operator's permit, motor vehicle title, motor vehicle's registration, or identification card issued by a Department of Motor Vehicles. So really plain English, it's information in or tied to your DMV file. License, ID, title, registration could fall under these DPPA rules. Basic rule is if the state agencies generally cannot disclose personal information from these records unless the disclosure fits one of their statutory exceptions. Whew. In 2014, the Ohio Attorney General, I want to say it was Husted, but I could be wrong. I'll have to follow back up with that. It's like I'm drawing a blank, but basically put in an opinion, the DPPA and another Ohio rule prohibits disclosure of personal information gathered by the BMV in connection with the motor vehicle record unless the disclosure is expressly permitted by statute, and that restriction can apply even when another agency like the Secretary of State receives that information. So why does this matter for voting? Why am I talking about your driver's license? Well, because when you go to update your address or to renew your license, sometimes they ask you if you want to register to vote. So that means some voter registration data can still carry protection, basically depending on where it came from and how it's used. Now, a huge exception for the DPPA is it can be disclosed for use by any government agency or someone acting on behalf in carrying out its functions. So it doesn't block all of the government use, but it does require it to be legitimate, relevant, and tied to the agency's lawful function. So the legal question isn't just whether the data was shared, but whether it was necessary and justified under the law. And my thoughts, my opinion, again, remember, this is just education. We're just talking. We're just spitballing here. This is not legal advice. I'm not your lawyer. You're just listening to some stuff that I found on the internet and I printed out, right? That's all, not legal advice. My thoughts is that the way that the DOJ demanded this information, wasn't necessary and it wasn't justified under the law, because the memorandum, which I don't know if you saw that video that I talked about that DOJ had states sign, talked about what they were going to do with this information. It was to analyze and assess voters and decide who could be on the voter roll and if they needed to be kicked off voting rolls and registration. And the state then you only had 45 days to kick these people off. And the thing is, states are statutorily and historically in charge of their elections, not the federal government. Also, that whole 45-day rule, it violates the NVRA, that rule we were just talking about. So courts have held that the NVRA doesn't cover this and it's not part of their authority. So this is my opinion. Again, not legal advice. Now we can talk about constitutional privacy, right? That's an avenue that people would think that they would be able to sue on. And the thing is, I think a lot of people think that the Constitution, in normal times, in normal world, because the world we live in now, we see the Constitution doesn't seem to matter, but the Constitution does not broadly protect voter registration information. In practice, courts have treated most routine voter registration information as having limited constitutional privacy protection, but certain parts of our information, well, that does have stronger protections, and that would be Social Security numbers or other highly sensitive identifiers. So this is just what I found. Don't be mad at me. Don't shoot the messenger. Another issue for constitutional issue would be the First Amendment, which might sound like what, but in some cases, courts have been concerned about compelled disclosures. So basically giving out our information, it might chill political participation or association rights. Like people might be worried to vote because the government now has their information and they might be scared that there'll be some type of punishment. I'm not saying that's going to happen. I'm just saying, look at the times that we're in. Registered voters may also want to think about claims under the 14th Amendment, right, to informational privacy when the government discloses our personal data without adequate justification or safeguards. Although courts don't treat this as an automatic violation, they also don't ignore it. So this is a possibility. The legal standards courts usually apply would be the person has to show a legitimate expectation of confidentiality of the information. So you think that your information was safe. Second, the government must show that the disclosure serves a sufficiently important, sometimes compelling state interest. And third, the disclosure has to be done in a narrow and minimally intrusive way. So basically courts are going to look at, did they do something further than necessary to carry out their scheme, right? There is a case out of Kansas oh, I didn't write the date down. Or so Moore, I think it's 2014, 2013, Moore versus Kobach. And basically there was a situation where Kansas, there was like this website that they used to cross-check, and it mixed up people's information with information of voters from other states. They shared this information and some people sued. It ended up being settled, but the court did recognize that voter data often includes highly sensitive identifiers like name, home address, dates of birth, and partial social security numbers, and that this type of information can fall within the scope of constitutional privacy protections when mishandled. You can look up at that case I found in the ACLU. So basically, courts have acknowledged that this information is not just abstract paperwork, right? It actually includes real identifiers that could harm people if they're misused. It could cause chilling effects on political participation, and there are some constitutional concerns, okay? However, courts have also been clear that not every violation of state privacy automatically triggers a federal constitutional case. It's going to require something more than the disclosure, and it's going to have to be egregious and unjustified and poorly safeguarded where it crosses constitutional lines. All right, let's talk about the practicality of all this, right? It's a lot of information. Again, just talking here. We're just like over a glass of wine. I'm just sharing some information that I learned. I'm educating you. Informational, not your lawyer, not legal advice. So here are realistic paths that my research kind of showed. A DPPA claim that could be viable if the information that was disclosed is covered by DPPA and didn't fall within the exception that we talked about earlier. Constitutional privacy claims under the 14th Amendment, we talked about those, but you have to show a legitimate expectation of confidentiality and that the disclosure was not adequately justified by law and was not narrowly tailored. Civil rights claims, which 42 U.S.C. 1983, we didn't talk about this earlier, but it's the main vehicle for bringing federal claims against state officials. The issue there is going to be immunity for the states and for like the secretaries, the officials, right? And it has a huge legal threshold to get over. And then like any type of financial benefit or like, I can't even think of it. It is not likely to happen because monetary judgments are really hard to come by. And it's mostly going to be like injunctive relief or what can we do so this doesn't happen again? We need to put safeguards in place. So some of the problems we're going to run into is we don't have full transparency. Is it exactly how things were shared or what exactly was shared? What legal authority LaRose relied on? What legal authority the government relied on? We know from some of the lawsuits, but here's the takeaway after almost 12 minutes or 13 minutes. Ohio sharing voter information, it's not automatically unlawful, but it does lead to a lot of questions. And there are some situations where perhaps a legal case could survive dismissal. The DOJ is going to say they have authority, but states are the ones who usually do their elections. So there are real legal limits and issues if confidential records were included, sensitive information like social security numbers were disclosed, and the data came from motor vehicle records and didn't fit a DPPA exception. So the biggest thing we need to do is, this is going to be huge for strategy. We cannot shut up about this because this was our private information and they aren't being transparent about exactly what was shared or how it was shared or what safeguards were put in place to ensure that we are protected. We want to see about policy change, and we don't want this to be swept under the rug. That was a very long explanation, but in my defense, I told you it was going to be. So it depends. It's not looking fantastic. Lawsuits are expensive, guys, super expensive. So what I would recommend is take this information, share this information, and understand that elections have consequences and who we put in power matters. And it doesn't just matter once in a while. Check your voter registration status every single day. Make sure you are not being purged. Keep talking about this. Okay? that's my one ask of you. I did this research. If you have any questions, please let me know. There's a lot more stuff that I left out, believe it or not. That Moore case is really interesting. But again, this was not legal advice. This was just me chatting with you over a glass of wine, sharing what I learned, because I'm a lawyer, not your lawyer. Educational and informational purposes only. Okay? Register to vote if you're not. Check your registration status and your precinct and all that stuff. And pay attention. They're counting on us to get tired. Don't do it. Cheers.